Mr. Fahey,
Yes, Judge.
I don't know if you have anything to add. I think this would be the appropriate time, or,
Well, Judge, the entire exhibit's in evidence, so
okay,
you're not going to consider it.
okay. State,
State called Steve Maris.
Your Honor, before Mr. Maris testifies, may I be heard?
yes.
Thank you. Your Honor, I had a trial in this case. The defendant's filed. We filed on behalf of Mr. Walsh and adopted by co-defendants in this case a motion to exclude statements of purported co-conspirators, in particular to exclude statements of our co-defendants in this case, which we did not have the opportunity to confront, and of course to exclude statements of individuals that the state has designated as unindicted co-conspirators in this case. The expectation is that Mr. Maris will be the final witness the state is going to present in their case against Joe Walsh. The furtherance of this appears to be that they will be admitting CPD email 12, CPD email 1, 9, 8, 11, 3, CPD email 4, CPD email 5, CPD email 10. That is my expectation. Those emails are emails that contain statements authored by never Joe Walsh. In fact, the emails contain statements of individuals by the name of Dan Gallagher, individuals by the name of Tony Wojcik, an individual by the name of Ron Hosko, representatives from the Federal Bureau of Investigation, chain emails, documents, and they're being offered, as we heard in pretrial hearings on this case, as an exception to the hearsay rule under 801D2E. These are statements by co-conspirators made during and in furtherance of the conspiracy charged in count 1 in this case. As you will recall, when we filed this motion originally, you heard arguments on it, the state made a proffer to the court. In essence, made the argument that, Judge, this is what we expect the evidence to show. This is how we intend to prove the existence of a conspiracy as it relates to Officer Joseph Walsh, and that the appropriate way to do this is for you to hear the evidence in this case, and if you find that we prove the existence of a conspiracy, then we can show that these are statements made by co-conspirators during the course of and in furtherance of the conspiracy. I spent some time last night reading the transcript and the arguments on that hearing. And I want to talk a little bit about what was proffered to you that the state said that they would be proving to prove the existence of a conspiracy in this case. And the first thing that the state offered was as follows. And on the night of the shooting, the state intended to prove that they, meaning the 3 men that are on trial here and others, had a meeting overnight. Now, the only evidence that you have heard of a meeting that occurred on October 20th of 2014 was the most recent witness or exhibit that was entered by way of stipulation, which is federal grand jury testimony of co-defendant Thomas Gaffney. That evidence cannot be in any way, shape, or form against Joseph Walsh. You know that. Parties have agreed to that. Thereafter, actually, in the presentation the state made to you ahead of trial, which is why I had the question going into trial, which is how do you intend to present Gaffney's statement and our objections to it. And of course, they agreed that it only comes in as Mr. Gaffney. They actually argued to you, Judge. They said, Mr. Gaffney's statement will prove that all of these individuals were in the same room talking that night. And that was, according to what the state presented to you, that's where the conspiracy began. And again, that evidence has not been presented in this trial against Joseph Walsh or Mr. March, for that matter. They further, in their proffer, told the court that they intended to prove that Detective Marsh directed officers to confirm what he says the video shows. Well, first of all, there was no evidence presented during the course of the trial that that happened in any way, shape, or form. And perhaps most importantly, as to our position, there's no evidence that that happened as to Joe Walsh at all, that Mr. Marsh ever directed Joe Walsh to confirm what Mr. Marsh or Detective Marsh said that the video showed. State told you that they were going to prove to you that the officer battery report was false, and actually repeated over and over again, false, false, false. Because Joseph Walsh submitted an officer battery report that, and that no one was battered in this case. But the state called to the witness stand Sergeant Snelling, who was an expert on these officer battery reports, and he told you, and the form itself, which has been admitted into evidence, tells the court that an officer battery report is to be used whenever an officer is the victim of an assault, an aggravated assault, a battery, or other crimes of violence. Thereafter, the state told you that they would prove the conspiracy by offering to you that a TRR was never supposed to be completed in this case. You were told that. And again, it was repeated, false, false, false. A TRR should have never been completed by Joseph Walsh. However, you will recall the testimony of Sergeant Snelling. Sergeant Snelling testified during the state's case in chief, judge, and on direct examination, I think. He certainly did during cross-examination, that the way the system was set up in October of 2014, in order to fill out an officer battery report, a police officer like Joe Walsh had to fill out the TRR first, despite the fact that he may not have ever used any type of tactical response or any force on the subject in this case. But that's the way the system was set up. So again, the evidence that was presented at trial is different than what was proffered to you. Similarly, they made the same argument as to Mr. Gaffney, and of course the evidence on that is exactly the same. It was proffered to you that you would hear evidence during the course of this trial that Detective Marsh falsely reported what Joe Walsh, Jason Van Dyke, Thomas Gaffney said to him, and that it was reported in GPRs and supplemental reports. Now that the evidence is about to come to a close, I think it's important to recognize that there's no evidence that's been presented to this court that Joe Walsh made any statement to his co-defendant in this case, and that the only thing that's being offered is a co-defendant out-of-court written statement that makes a reference to an interview of Mr. Walsh. And that is hearsay, and that statement should not be entered against Joseph Walsh unless, of course, the state can prove the existence of a conspiracy between him, Detective Marsh, and Mr. Gaffney, and they have done so in this case. The only witness that even testified at all about a GPR or a supplemental report that had information in it that they took issue with or claimed to be information they did not provide was Dora Fontaine. But rather, ahead of trial in this case, the state told you we were going to prove a conspiracy in this case by proving to you that Detective Marsh falsely reported what all these witnesses, they said, Van Dyke, Walsh, Gaffney, McGelly, Sebastian, all these other witnesses. You haven't heard any testimony that any of the GPRs that are before you, any of the supplemental reports that are before you at this point in time contain false statements by other police officers. That testimony has not been presented. Once again, later on in the argument, state goes back again to tell you that specifically that Thomas Gaffney's statement to the federal grand jury proves the existence of the conspiracy. That is inadmissible against Joseph Walsh. In conclusion, what the state argued to you, Judge, was that if, when you see the video, which is People's Exhibit 813R- is inconsistent with the reports, then we've proven our case. Well, you heard all of the testimony. We're coming to an end. You're not going to have a live witness anymore. You understand now from seeing that exhibit, and particularly hearing the testimony from the state's own witnesses, that the content of that video is limited. Sergeant Snelling actually told you that. Ms. Fontaine testified that her view from coming up from the other angle was completely different from what Sergeant Snelling saw. And perhaps most importantly, simply because someone subjectively believes that that dash cam video is inconsistent with the written reports in this case, you still need to get to what the elements of a conspiracy are. And the state must prove, at least to get admission by a preponderance of the evidence, that there was an agreement between these three men to commit a specified unlawful act. In this case, it's two separate offenses. They need to meet the elements of obstruction of justice, and they need to agree to meet the elements of official misconduct. And I think most importantly here, they haven't been able to even put Joe Walsh in the same room as these two other individuals, much less Jason Van Dyke, who they referred to in the indictment as individual A. They haven't presented evidence of a phone call between Joe Walsh and any of these other alleged conspirators on the night of this event. A text message, an email. They can't put him in the room where they say this happened. And they have to do that, Judge, in order to admit this rank hearsay against Joe Walsh. All Joe Walsh did that evening, Judge, which was consistent with what we opened in this case, was he was on scene for the shooting. He did two reports, which you heard of every witness that the state called here to testify were things that you get directed to do in these types of circumstances, and he went home. He had no more involvement with this case. He had no communication with the FOP. There's no evidence of that. He had no communication with any supervisors, whether it be lieutenants, captains, commanders who were on the scene. There's no evidence of any type of communication whatsoever that the state could even create an inference of a conspiracy that involves Joe Walsh. And I'm sure that they'll get up in response and say that we've proved it by inference. No, we can't show that there was an actual agreement. But even when they're going to offer you an inference, that inference must be reasonable. And it must be based on the evidence they presented, Judge. With all due respect, they haven't presented the evidence that they proffered to us ahead of trial that they said they were going to show you to prove the existence of the conspiracy. And for that reason, Judge, I object, once again, to these emails being offered against Joe Walsh. And we also object to the exhibits that had come in previously and conditionally under our objection, unless the state has additional witnesses that they tend to present, and I don't believe they do, where they believe can advance this conspiracy that included Joe Walsh. I'm making an objection.
Thank you. Mr. McKay?
I adopt Mr. Pugh's argument, and I will just briefly add on behalf of David March's position on this issue is this. The state has failed to provide to this court evidence that David March ever met Mr. Walsh and Mr. Gaffney, and more importantly, there has been no evidence presented to this court that Detective David March communicated in any way, whether he's in the same room or otherwise, and in any way communicated with Officer Walsh and Officer Gaffney. In addition to that, Judge, regarding the emails the state seeks to introduce at this juncture of the trial, there is no email from David March. Period. There is no email where David March is a carbon copy or a CC on it. There is no email where David March is even a blind carbon copy. They want to put in emails, many of them well after the fact, against David March and the two co-defendants. They haven't linked up that there's any agreement between these three men at all. And now they want to put in emails by authors nowhere near this courtroom against David March. And you will see, I'm not just saying this, none of these emails are from David March. None of these, there's no evidence that David March even knew about these emails. Now, there is an email from a lieutenant to David March. But for that, these exhibits, I firmly believe, should not be admitted because there has been absolutely no evidence to establish that a conspiracy even exists here. And in addition to adopting Mr. Pugh's argument, thank you very much.
Okay, thank you. Mr. Fahey?
Judge, I would also adopt arguments of co-counsels. And with regards to Mr. Gabbard, Judge, there is no evidence that he ever agreed any kind of conspire to conceal the true facts of what really happened in the shooting of LaQuan McDonald. As the evidence is clearly established, he wasn't even a witness to that. They presented his grand jury testimony, and yes, he testified very honestly that hours later, he did go back to Area Central at standard operating procedure. And yes, he was in the area. It's a large area, large room. There are other officers there. That doesn't mean they were conspiring. They had already been interviewed by detectives. This is hours later by the time he even arrives at the area. And yes, he's entitled to talk to his union representatives before he is interviewed by the Independent Police Review Authority. That's standard operating procedure. There's nothing wrong with that. And there's certainly no evidence to suggest that he participated in some conspiracy about a shooting that he did not even see. And now we have evidence that the state wishes to introduce from people my client doesn't even know. He has no connection to, and he had no knowledge of these interviews. And they're months later, after the incident, where my client no longer has any more involvement with the investigation. He's done. His only involvement in this investigation was when he was cooperating with every single investigation that followed up after the shooting. There's no evidence of any agreement at all that has been presented with regards to Thomas Gaffney, and there certainly is no evidence that he did anything further of it. So we would join in the objection, Your Honor.
Thank you. State?
Thank you, Your Honor. The court should deny the defendant's motion to reconsider the court's November 5 ruling. And now that we're going to go through what the defendants claim the state proffered but failed to prove, we should correct the record for defendants that have now misstated the record. The first is that there is no independent basis for the statements contained in the police reports, and that they are all hearsay. As the state laid out in its co-conspirator proffer, filed on June 7, 2018, under Illinois Rule of Evidence 801C, hearsay is only a statement offered in evidence to prove the truth of the matter asserted. When the statement is not offered to prove the truth of the matter asserted, it does not constitute hearsay. Out-of-court statements are inadmissible when they are offered for their falsity. Anderson versus United States, US 417 US 211 220. The point of the prosecutors introducing those statements was simply to prove that the statements were made because they were false, not for the truth of the matter asserted. The state did not offer March case sub 2 for the truth of the matter asserted, Your Honor. And if that hasn't become clear to this point, we can make it perfectly clear. Joe Walsh stated that he backed up attempting to maintain a safe distance. That is directly contrary to 813R-2. The defendants have argued that they approached each other. That's what the video shows. It shows defendant Walsh and Van Dyke walking in the direction of Laquan McDonald, not backing up. That statement was not offered for the truth. It was offered for the falsity. That's an independent basis for the court to consider that statement. Joe Walsh further stated, when Laquan McDonald got to within 10 to 15 feet of the officers, he swung the knife toward the officers in an aggressive manner, contrary to 813 R dash cam. As a matter of fact, at some point during cross-examination, one of the defense counsel said, does it appear at this moment that Laquan McDonald is moving his arm to the right, showing the knife? Joseph Walsh isn't even around his car at that moment and is blocked in the view on 813R with the vehicle that is in between them. That is Letty Velez's vehicle. He can't even see where the defense counsel cross-examined to say he is opening his knife. The fact that Joseph Walsh said when Laquan McDonald got to within 10 to 15 feet of the officers, he swung the knife toward the officers in an aggressive manner, not offered for its truth, offered for its falsity, has an independent basis. Joseph Walsh further stated, Van Dyke continued firing his weapon at McDonald as McDonald continued moving on the ground, attempting to get up, while still armed with the knife. Again, offered for its falsity, not its truth. That statement has an independent basis for admissibility. March also reports that Joseph Walsh related the same facts as his partner, Officer Jason Van Dyke. Let's discuss what Jason Van Dyke told defendant March, wrote down in the case supplementary report, and is offered for its falsity. When McDonald got to within 10 to 15 feet of Officer Van Dyke, McDonald looked toward Van Dyke. McDonald raised the knife across his chest over his shoulder, pointing the knife at McDonald, at Van Dyke. Contrary to 813 Robert, contrary to the testimony you've heard in this case, including Dora Fontaine. But most simply, we watched the videotape together. We watched 813 Robert together. We went through it multiple times with both state and defense cross-examination. 813 Robert does not show McDonald raised the knife across his chest over his shoulder, pointing the knife at Van Dyke. In defense of his life, Van Dyke backpedaled and fired the handgun at McDonald to stop the attack. That statement, not offered for its truth, not hearsay, offered for its falsity, the court can consider that statement. Van Dyke continued to fire his weapon at McDonald as McDonald was on the ground, as McDonald appeared to be attempting to get up, all the while continuing to point the knife at Van Dyke. Contrary to 813 Robert video, contrary to the testimony that you've heard in this case. The state also introduced testimony from Dora Fontaine. March reports Dora Fontaine stated that Laquan McDonald raised his right arm as if attacking Van Dyke. Not offered for its truth, offered for its falsity, Dora Fontaine testified unequivocally as to that statement that she did not make, and it was false. And we heard this morning, she was again confronted at OIG about making that statement, unequivocally denied making that statement, and it's false. And objectively, looking at 813, Robert, we know it's false. Defendant March takes these statements together, Your Honor, and writes a case supplementary report. As we heard in opening, and we are talking about the admissibility of evidence, and concludes the recovered in-car video camera from beats 845 Robert and 813 Robert was viewed and found to be consistent with the accounts of all the witnesses. That statement is false. That statement has an independent basis for admissibility because it's offered for its falsity, not for its truth. In the final page, page 22, and I remember spending 3 hours with Mr. Perfetti, and I apologize for going over this again, Your Honor. This is a report by David March, Daniel Gallagher, Anthony Wojcik. Anthony Wojcik writes the conclusion for David March, includes it in this report, and that conclusion is provided by email, as Mr. McKay just said, stating the above two-day investigation determined that Laquan McDonald was an active assailant who, while armed with a dangerous weapon, used force likely to cause death or serious injury, threatened the imminent use of force likely to cause death or serious injury when he incised the tire and stabbed the windshield of a Chicago Police Department vehicle occupied by Officer Thomas Gaffney. That statement is offered for its falsity, not its truth. What evidence is there that that statement is false? Officer McElligot's testimony that he did not observe Laquan McDonald using imminent force likely to cause death or serious injury. We also know that is false by Gaffney's own sworn admission that you just heard, that he did not believe. He testified that there was no use of force likely to cause death or serious injury when that occurred. And initiated imminent use of force likely to cause death or serious injury when he initiated an attack on officers Jason Van Dyke and Joseph Walsh. We know that is offered for its falsity and not its truth, which has an independent basis for the court to consider. The evidence of its falsity is 813R, watching the dash cam, and its falsity is shown by Sergeant Snelling's testimony. That there was no imminent use of force likely to cause death or serious injury at that moment. Sergeant Snelling also testified there was no assault. So Sergeant Snelling also testified there was no battery. Sergeant Snelling also testified that on the TRR, the defendants, Walsh and Gaffney and Van Dyke, should have marked fled.
Objection. That wasn't his testimony with regards to Gaffney.
Mr. Fahey makes my point. There's no basis for Gaffney to provide facts that he does not know unless he's getting them from someplace else and writing down false information.
Objection.
We've heard
There's
that
absolutely no evidence.
Okay, 1 second. You didn't even rule on the first objection, and now the second objection. Your objection is noted but overruled. I heard the evidence, and I'll only consider the evidence that is accurate.
Thank you, Your Honor.
Thank you, Judge.
You can continue.
No one should have marked imminent use of deadly force. No one should have marked battery. No one should have marked assault. What they should have marked was fled. No one marked fled. All of them marked false information. All of them marked consistently false information. And while it may be good police work to get together back at the area to write true reports, no one can get together back at the area to write false reports. The conclusion is the above investigation that Officer Jason Van Dyke use of deadly force, the discharging of his firearm was within the bounds of the Chicago Police Department's use of force guidelines and in conformity with local ordinances and state law. Again, offered for its falsity. That has an independent basis. We could go over again all the case reports that we went over for substantial amount for Betty's testimony. It was offered for its falsity, not its truth. All of those have an independent basis. On the officer's battery report, an identical number of 3 was written on all of them. 3 officers were not assaulted and battered. 3 officers were not assaulted or battered. However the defendants want to argue it, they're welcome to argue it. There's no basis for them to claim that 3 officers were assaulted or battered and battered. The evidence is no assault occurred, no battery occurred. On the officer's battery report, Walsh, Gaffney, and Van Dyke all put the identical description of swinging knife as well as other identical information on their officer's battery report. Officer offered for its falsity, not its truth. The idea that the only testimony about a meeting was Gaffney, again, not true. McDelegate testified detectives and Joe Walsh and Jason Van Dyke were watching the video when McDelegate came to Area Central, and they were watching the video, and detectives were pointing out, see where you're backing up. That's offered for its falsity. That's evidence of a meeting at Area Central without regard to defendant Gaffney's testimony. This motion for reconsideration of the court's ruling should be denied. There is sufficient evidence for this court to continue to find, as the court found on November 5th in its ruling, that the state has carried its burden under 801 D2 for the admissibility of hearsay co-conspirator statements as a statement by a co-conspirator, which is an out-of-court statement by a co-conspirator in furtherance of the conspiracy. The state has met its burden of preponderance of the evidence. To allow the admissibility of co-conspirator statements under People v. Leak 398, Hill Ave. 3rd, 798 at 826, 1st District, 2010. The state has carried its burden with regard to independent basis for admissibility as it's set out in its co-conspirator proffer, as it's set out in length at a hearing where it detailed and gave notice to the defendants of those statements. Defendant's motion, I guess it's for reconsideration, should be not denied. The state should be allowed to call Steve Maris and proffer its evidence.
Mr. Pugh?
Yes, Your Honor. Your Honor, what I just observed was probably one of the most disingenuous and unfair things that I've seen in a court of law. We had some 60 pages of filings before the court, and you were told that the Marsh subs and the other out-of-court statements by co-defendants were being offered as co-conspirator statements under 801 D2E. And I just listened to a 30-minute presentation where the state now takes a position, probably because they're conceding they've never proven a conspiracy during the course of this trial, that you should consider those statements under 801C as out-of-court statements not being offered for the truth of the matter asserted therein, which is the first time we've ever heard this basis. Even at the beginning of this trial, when we were objecting to them coming in, there was no representation made to that. And what that representation means really, in many respects, is, with all due respect to Mr. Watson, he doesn't understand the rule. Because if he's going to offer an out-of-court statement, not for its truth, but rather for its falsity, then it's only admissible against the declarant of that statement. And it is not admissible against somebody else. Yet you heard that he has offered to you that Marsh's statement, where he is a declarant, is being offered for its falsity, but you are to consider it against Joe Walsh as a statement of Joe Walsh. You can't do that. Because were you to do that, they're going to force a severance in this case at the end of the trial. Because you can't put in the statement of one person and within that statement ask you to consider the statement of another person where, one, you don't have any foundation for it. Two, if you are to do what he suggests you do, is to consider the entirety of the Marsh written statement, which purports to be a statement of Joe Walsh, I have no ability to confront the declarant of that statement because the declarant is my co-defendant in this case. So even under their new theory of admissibility to these out-of-court statements, what they're doing is forcing a mistrial in this case, Judge, and they're forcing a severance in this case, because if you are going to consider, one, that these statements are admissible under 801C, they can only be admissible to the declarant and not to somebody else's statement that is contained therein. I heard really nothing as to why these emails that are being offered, which is what my objection was, why these emails are somehow, they've laid the foundation that these are statements by co-conspirators made during the course of the conspiracy that are made in furtherance of the conspiracy. I didn't hear anything about that. All we did was dwell upon what's been referred to, who has been admitted into evidence provisionally at this time as the Marsh GPR substance in this case. And as I hear it now presented to you, they would like you to consider that as a false statement of Joe Walsh in this case, which is wholly inappropriate and grossly unfair after all the pretrial motions. If you look at what their Santiago proffer was that they made in this case, they proffered they'd be admitting these under 801 D2E. When objected on day one of the trial, we're told it's the same as the pretrial order from 11-5. Now here we are at the end of the trial, and they have this alternative theory of admissibility, which even if you were to buy into that, would only make the statements admissible against the declarant, who is not Joe Walsh.
Thank you. Mr. McKay?
I join that argument. I would only add that I heard no argument from Mr. Watson, and I certainly heard no evidence whatsoever in the state's case up to this point that there is an agreement. Mr. Watson is jumping ahead of certain things that the state must prove during their case. First, that there is an agreement between these three men, and that once that agreement is reached, then statements are made in furtherance of the conspiracy. Let's get to the very first element. Where is the evidence of an agreement? It is the most important element for a conspiracy. There is no evidence whatsoever, nor was anything argued by Mr. Watson, that there was ever an agreement at any time that night and any time thereafter. There's no evidence that David March was at the area until much later. Certainly nobody identified David March as a detective at the area talking to people, but for Miss Fontaine, who said she heard nobody talking about the case at the area. You've heard the evidence, Judge. I don't need to elaborate further. I would just say the bottom line is that these co-conspirator statements, right? These alleged co-conspirator statements, by the way of these emails, should not be admitted at all because the state has failed to prove up an agreement. Thank you.
Thank you. Mr. Fahey?
Judge, it's clear that the state is conceding on the conspiracy, and rightfully so, because there's absolutely no evidence of a conspiracy. There's absolutely nothing that you can infer an agreement of a conspiracy. And with regards to admitting these as false statements, I'm going to adopt the arguments of Mr. Q and Mr. McKay, and I would submit that. Thank you.
Thank you. I normally don't go back and forth, but I will in this instance. Mr. Watson, anything further? But I'll also give the defense an opportunity because it's their objection.
Parallel false statements is evidence of an agreement. These statements are offered for their falsity. They're offered as a statement of the conspiracy. I could go through the emails. It's important would like me to go through the emails to independently show each of these. If that's what the court would prefer, we can take these up now.
It's
okay.
Their objection and your response, however you want to proceed. I don't tell the parties how to proceed.
I wanted to, as we cited in our proffer, the court considers and takes up the admissibility in the totality of the evidence. I think this is premature based on the emails that we are offering, but we will go through the emails. CPD email 1 is an email from Daniel Gallagher from his private email account. Daniel Gallagher is the sergeant who writes the false case supplementary report to Anthony Wojcik. Anthony Wojcik is the lieutenant who writes with Gallagher and March that false case supplementary report. Daniel Gallagher states, Jason Van Dyke is aware.
Judge, I can object. He wants to publish
hold on, 1 second.
No,
1
Will,
second.
may I for just a second?
No, 1 second, Mr. McKay.
Of course.
Those are in the binder, correct?
Yes, Your Honor.
I think it's more appropriate, if you want me to consider them, for the court to consider them in camera at this point.
Thank you.
And that would resolve the objections, because I think go ahead, you could say your
I have
objection.
something. Mr. Watson just misstated this email. It's from Daniel Gallagher to Anthony Wojcik, not David March. He mentioned Mr. March's name. He's not a recipient of this email.
Okay,
I said he was the author of the case summary 2, along with Wojcik and Gallagher. That's true. There's no dispute about that.
David March is an author of a police report. He's not a recipient of this email.
okay.
And there's no email in their exhibits that's going to suggest it was sent, a copy to him, or he received it somehow.
Tab 6, Your Honor.
I have to find Maris, right?
You do, it should be under Maris already, tab 6.
Tab 6.
Oh,
I got it.
tab 5, Your Honor.
Okay, because I do see on CPD email 2. It's CPD email 1.
Yes, Your Honor.
Is this the only email? Or there's more than one?
There are more than this. Your Honor.
Okay. Okay, so I guess the question is, for me, do you want me to look at these in camera, or is the defense objecting to them being read out loud?
Yes.
Okay, but Mr. Watson, you want me to consider them?
Well, Mr. Pugh argued that you didn't hear one statement by me about the emails. I'm going to now argue these, including the basis for its statement being in furtherance of the conspiracy.
Are you going to get into the emails, the content of the emails?
Yes, Your Honor, in order for the court to consider, because you have to look at the statement to decide whether it's in furtherance of the conspiracy or whether it is in fact admissible under the co-conspirator exception. That statement itself.
I'm going to take just a short recess. If there's no objection, I will read these in camera. Any objection, Mr. McKay?
Not from me, Judge.
Mr. Pugh?
No, Your Honor.
No, Your Honor.
Okay, Mr. Fahey, state.
Yes, Your Honor, I would direct you to specific emails that would help the court's review.
Sure. Which ones?
CPD email 1, tab 5.
1 second. Tab 5?
Yes,
Okay. Okay,
CPD email 2, tab 6.
okay,
CPD email 11, tab 9.
okay,
CPD email 3, tab 10. CPD email 4, tab 11.
okay,
CPD email 5, tab 12. CPD email 10, tab 13. And finally, Your Honor, CPD email 6, tab 14.
okay. Court's going to be in a short recess.
Thank you, Your Honor.
The record should reflect that all of the defendants are present, all of their attorneys are present, all of the special prosecutors are present. In fairness to all of the parties, the court's going to take additional time to review my notes, to make
a ruling on this issue, which would include the emails. I know we're not going to meet tomorrow, so I think, or Monday, that was discussed. So can we meet on Tuesday?
Your Honor, I'm probably the only person with a problem on Tuesday. If we were to start at 1 o'clock in the afternoon, I'd be able to be here.
I could do that. Is that a good time or date for everyone else? Mr. McKay?
I can be back at any time, Your Honor.
Thank you. Mr. Pugh?
Yes, Your Honor.
Mr.
I'm
Fahey?
available any.
State? State?
Sure, Jim.
And if we could just discuss just a few housekeeping matters. If we don't finish on Tuesday, which I don't know if we will or not, I would like to hold it from Tuesday to Wednesday if we need to go into Wednesday. Is Wednesday available for everyone?
It is for myself and Mr. Martin.
Okay.
Good for myself and Mr. Green, Judge.
Yes, Your Honor, I'm available.
State?
Yes.
Okay, so this case, all defendants order a court December 4th? December 4th with per bench commenced and continued at 1 o'clock.
Judge, if we can approach the bench for just a second and ask a question before you release it.
Before, okay, off the record?
No,
On the record, okay. Judge, one second. The court reporter can't hear you. Is this something? Okay, then just talk so the court reporter can hear you.
We had additional stipulations that involve emails. We're not necessarily sure if those are also going to be subject to.
Do you want me to just read them all?
So,
Are they in the binder?
No, Your Honor. Oh, these are new emails?
no,
These are
it's the stipulation.
stipulation that Mr. McKay and State.
So what are you asking?
That the court received that stipulation?
Oh, today?
Yes, Your Honor.
I could do that.
Yeah, because they involve the emails also. So you may want to consider it today.
Just so I'm clear.
Okay, let's back up. Mr. McKay. All right, so let's back up. Ms. Brown-Holmes or Mr. Watson, you're asking to have this additional stipulation entered today.
Yes, Your Honor.
And Mr. McKay, since it's a stipulation, I assume you have no objection, or is that incorrect?
It's provisional. I would stipulate to the foundation of the emails if you.
Based upon my ruling.
True. So, I will go along with this only if our motions are,
So what happened is.
Are
there
these
was a-
additional emails in that binder?
There.
No, it was a stipulation that was entered into by two of the council provisionally.
Right.
A subset of them were not stipulated to by Mr.
Mr.
McKay
Okay.
until
I
we
rule.
got today's stipulation from Mr. McKay. So that kind of completes all three defendants with all of the stipulations. And so we just wanted to bring that to your attention.
Sure.
It's all still provisional, of course.
Right.
I'm not saying that they agree. But the stipulation entered today, or that we just gave to you today, from Mr. McKay and us, makes everybody complete.
Right, but
Okay.
I think People's Exhibit CPD emails 1 through 12 are in the binder, aren't they?
That's true.
So everything that's in the stipulation, the court is already in possession of.
Got it.
Exactly.
Nothing new.
That's all I wanted to know. Do I have it, or I don't
You
have it?
everything.
And if I don't have it, am I supposed to get it? That's
You
all.
have it.
You have it, Your Honor.
Great. Anything else?
I may have one.
Sure.
The state also offers Walsh OBR Clear 1 and Walsh TR Clear 1, Your Honor, by stipulation.
Hey, Rob?
The
Okay, so this is just for Mr. Walsh? Is that correct?
No, Your Honor.
Oh.
It's the People's Exhibit.
People's Exhibit. And that's just what it's labeled,
That's what it's labeled, Your Honor.
but it's for all three defendants.
Yes, Your Honor. The parties further stipulate.
Okay, so it's Walsh, OBR, Clear 1. Court's in session? Okay,
The parties further stipulate Walsh TR Clear 1 and Walsh OBR Clear 1.
you're asking if they be admitted?
I'm asking they be admitted and this following stipulation.
Okay,
The parties stipulate Walsh TR Clear 1 and Walsh OBR Clear 1 are how the forms appeared in the Chicago Police Department Clear system in 2016. At some point, the form was changed to reflect assault or battery as shown on Walsh OBR Clear 1. But the Chicago Police Department records are unclear as to when that change was made.
okay. So stipulated, Mr. McKay?
Yes.
So stipulated, Mr. Pugh or Mr. Breen? And so stipulated, Mr. Fahey?
Yes,
That stipulation and these exhibits are received and admitted.
The state offers Gaffney Affidavit 1 by stipulation.
Okay,
That's correct, Judge.
and this is only to be considered against Mr. Gaffney?
It's to be considered as to Mr. Gaffney, Your Honor. It is the sworn electronic signature verification affidavit of Thomas Gaffney for the Chicago Police Department. It states, I hereby acknowledge that the Chicago Police Department has assigned to me a unique computer system identifier known as a PC login identifier. I acknowledge that it is my duty to retain control of and maintain the secrecy of the password which I have created for use in connection with my PC login identifier. I further acknowledge that my PC login identifier, as verified by my password, shall act as my electronic signature and shall have the full effect as that of my written signature. It identifies PC number, PC.
I'm sorry, I'm very sorry to interject. I have just a moment.
Yes.
Mr. Fahey?
Thank you.
Identifies PC number PC 0Q763, employee number 8, strike that, Your Honor. Employee number 2327. It is signed by Thomas Gaffney, 19 February 2007.
Okay, so stipulated, Mr. Fahey?
Yes, Your Honor.
That stipulation's received and admitted, and the exhibit as well. Okay,
Your Honor, the state offers Walsh Affidavit 1. I'm sorry.
and if I didn't say it, the identification marks are stricken on those and admitted.
Thank you, Your Honor. The The state offers Walsh affidavit 1 by stipulation.
Is this only to be considered in Mr. Walsh's case?
Yes, Your Honor. Walsh affidavit 1 is the sworn electronic signature verification affidavit for the Chicago Police Department of Joseph Walsh. I hereby acknowledge that the Chicago Police Department has assigned to me a unique computer system identifier known as a PC login identifier. I acknowledge that it is my duty to retain control of and maintain the secrecy of the password which I have created for use in connection with my PC login identifier. I further acknowledge that my PC login identifier, as verified by my password, shall act as my electronic signature and shall have the full effect as that of my written signature. It identifies PC number PC0S571.
That's an S?
It's an S, Your Honor.
Okay.
Employee number 10016.
Okay.
It is signed by Joseph Walsh, 24 February 2007.
24 February 2007.
24 February 2007.
Okay, so stipulated, Ms.
Stipulated.
Okay, and that stipulation is received and admitted. The identification mark is stricken and it's admitted into evidence.
Thank you, Your Honor.
Okay, is that it for today? That's fine. Okay, then I will see everybody Tuesday at 1.
Thank you, Judge.
Thank you, Your
Thank
Honor.
you, Judge.
Court is adjourned.